You're claiming for the months that you've actually paid the rent, and I want to make sure I completely understand what you're claiming for before I rule.
Okay.
So you're claiming for May 2013, September, October, November of the same year, where you paid the full rent of £810, and also in December 2013, where you've paid £250. The total value of the claim, therefore, is £3,490 in respect of the rent. And you're also claiming for the DIY work that you did, which you say you weren't reimbursed for.
No, we weren't reimbursed.
Simon, when you rent a property to someone, you're under a number of legal obligations. One of the most important legal obligations, called a covenant, is that the house is fit for human habitation. One of the most important duties you have is to ensure that it's sufficiently warm. And in my judgment, not only did you do very little, but you did not behave to the standard of a decent landlord at any moment during the course of this short-hold tenancy. Not only did you not behave like a decent landlord, but it gets worse. Because the moment you were unsatisfied the rent was being paid, you acted in a way which, in my judgment, borders, no, it trespasses into the criminal. And you should be thoroughly ashamed of what you did in threatening a family in the circumstances that they found themselves in. Now, Rebecca, I'm satisfied that that rent was paid, and so to that end, you're entitled to the full amount of £3,490. Ordinarily, I would take off the relevant proportion that you were fairly prepared to take off, because what you say to me in your claim is, look, we used 4 rooms, so I'm prepared to pay for those 4 rooms. In my judgment, I'm not going to do that, because it seems to me that you're entitled to a house which is thoroughly habitable, not an upmarket, rather charming igloo. Do you understand?
Yes, sir.
So to that end, I'm prepared to award you the full claim of £3,490 in respect of the rent. Now, one of the things you've done for me here, which is very good, and you get your gold stars, is keep paper in respect of all of the issues in respect of the heating and the rent. And I've got sufficient evidence in that regard to come to a conclusion that you are owed that money, £3,490. I don't have sufficient information in my judgment to come to an assessment on the DIY work, and in particular who did what and when, and the extent to which Simon may, at the start of the life of the tenancy, begun to act decently. I'm afraid it went downhill after the moment you walked in. So to that extent, I can't award you anything for the DIY. Sad, but there it is. Nevertheless, I am prepared to award you the full amount that you're claiming for in respect of the money you paid for rent of £3,490, and that's the award of this court. Simon, when you rent a property, you have very, very serious duties. However stressed you are, you can't threaten people. I think this is a lesson, and an expensive lesson at that. The award of this court is £3,490, and Simon, your claim is dismissed.
Thank you, Judge.